ask you a question just about how this works? So if you think about the process that you've been given, it's Article 64, which allows you to make the motion to the trial court, which you did. And am I understanding correctly that you didn't really know about the no contamination requirement until the process started unfolding? So you couldn't have brought your challenge before you invoked Article 64.
That's
correct?
right, Your Honor.
Okay, so I'm thinking, well, Article 64 sets out the process that you're due. It gives you the trial court and then the direct appeal to the CCA, and the CCA has to take it, right? It's not discretionary.
In capital cases like this.
Capital cases like this one. So you got the appeal to the CCA, so it wouldn't have made sense for you to file your suit at the trial court because the process hadn't yet run, and part of the process that Texas is giving you is allowing for mistakes to be corrected,
That's
right?
right.
So then I think it matters whether at that point, all Article 64 says it stops after it says you get the direct appeal to the CCA. Now, it's part of the CCA's other procedures, right, that you can file a petition for rehearing. But should we really think of that as part of the procedure given in Article 64 for the prisoner to run through?
I don't know that I would agree that it's not part of the procedure for Article 64, because I think once you're put into the Court of Criminal Appeals, then of course the court's procedures apply. It would be like this court's jurisdiction tends to be certiorari jurisdiction, but if you had any kind of jurisdiction that gets you to this court, then you could invoke the court's normal procedures, or the same for the CCA. And I think in any event, the practical considerations and the federalism and comity considerations are strong. I think that it would be this court or the federal courts essentially saying to the state courts, we don't care what other mechanisms you have that are available. We don't care how often you may or may not change your reasoning, because that could also happen. So I think the only distinction the court could draw between the issue, between saying that the cause of action should accrue at the trial court's opinion versus the CCA's opinion versus denial of rehearing, is saying, well, we think it's a lesser chance that something is going to happen. But again, the procedure exists for a reason. And just as McCulloch with Justice Sotomayor at the beginning, you wouldn't expect, I don't think anyone could come to this court before they received a denial of rehearing or an amended opinion on rehearing before a federal court of appeals in much the same way.
Thank you.